Hi everyone, I'm Meera. I head up the M&A team at Buzzacott Corporate Finance. I'm joined here by John Young, lead partner in the M&A team at Kingsley Napley law firm today. And we're speaking here today about heads of terms as part of a series of videos to help demystify some of these difficult areas in transactions. John, thanks for taking the time to speak today.
Hi, thanks for inviting me, Meera, and I'm very happy to be here doing another video with you on heads of terms this time.
So can you start by briefly explaining what heads of terms are?
So heads of terms, sometimes also called a letter of intent or a memorandum of understanding, are a mostly non-binding explanation of the key terms of an M&A transaction. They're use from my perspective as a lawyer is to help me in understanding the basic terms of the transaction for when I start to put the documentation together. But from the party's perspective, the most important thing about them is they're a chance to sit down at the start and make sure that they are aligned on what they've commercially agreed and that there are no misunderstandings which could cause problems later on. If this process is done properly, even though it means some more work up front, it will mean a smoother, more cost-effective and quicker transaction because you aren't having arguments on points of principle and doing significant work on documents because you've talked about it in more general terms and you can write it down commercially so that people understand.
And I imagine there's a bit of a balance in terms of getting the level of detail right or not before you end up renegotiating or negotiating everything in advance.
Absolutely. There is a real danger of pre-negotiating the whole package, and sometimes it may be appropriate with particular things. Say, we talked about this, we're not quite going to get there on this issue now, but we know that we can get there and we will leave it. As long as you covered the main areas and flushed out those areas of disagreement, then it can be okay if you're close enough to move on to the next stage of the transaction.
So in terms of some of those key areas, I imagine consideration is one of those. Could we start talking a little bit about that and then come on to some of the other key points afterwards?
Yeah, absolutely. And consideration is, as you say, the key part of any set of heads of terms because it's the commercial. What the buyer cares about is what they're paying, and what the seller cares about is what they're getting at the end of the day. There are a number of areas which should be covered in the heads of terms and consideration. The first one, obviously, is going to be what gets paid on completion and what the fixed payment is. It's pretty common to have a mix of variable and fixed consideration in transactions, but from a seller's perspective, you desperately need to know what you're getting up front because that's the only thing you can guarantee you will get. The world changes, there is credit risk, occasionally banks blow up. So it's only the day one money you can be sure you're getting. The buyer, of course, as we've discussed before, may want to phase some payments, depending on things like performance or just to allow it to cash flow the business, or perhaps to have some form of retention should there any issues emerge, which it should rightfully be compensated for later in the transaction.
How often do you see retention being put in heads of terms at the moment?
So your old school escrow account retentions are quite rare these days. That's where you have a separate bank account controlled by the lawyers and cash is paid in on day one. That's because there have been changes to the regulatory regime and to the anti-money laundering rules over the last kind of 10-15 years, which makes that much more difficult. I think that a lot of transactions where there is a form of deferred consideration anyway will have the ability to set off any claims against that deferred consideration and a mechanism to allow disputes as to what any set off should be to be addressed by negotiation and possibly expert determination.
Yeah, definitely. And there's something we've seen as well. I know both of us do a lot of cross-border M&A work, and I think certainly the American purchaser's style is quite typical in having a fairly chunky retention in there. So it's certainly a theme we see quite a lot of from both our transaction sides. And thanks for talking about the kind of consideration elements. In terms of other key issues you mentioned, what are the other key points that sellers should expect to see or want to see addressed in the heads of terms?
So Crucial will be the consideration adjustment and how adjustments will be made. A buyer will usually want to have some kind of fixed position on the company, so he or she knows what she's paying for. There are a couple of ways you can do that, which we discussed in the previous video with your colleague James. One is that there can be completion accounts, which is where you take a snapshot of the company at the date of completion, and you say, okay, or you've agreed accounting policies and an expected level of debt and working capital in the business, and to the extent that the business is in a better position than expected, an additional payment is made to the buyer.
Thanks very much for that. I think the last piece on consideration in terms of the calculation are how any consideration adjustments will be made. What sort of considerations are there for that?
So when you're looking at adjustments at completion, the buyer will want to be comfortable that it's getting what it expects from the business, and the seller will want to be comfortable that they're not giving away more than they thought they were when the transaction was originally agreed. So it's common to have a mechanism that allows for an adjustment for that. There are two common types or ways of doing this, which we discussed with your colleague James in the previous video. One is a lockbox and the other is completion accounts. For completion accounts, essentially you take a snapshot of the business at completion and adjust the consideration to the extent that it is more or less than an expected position, which will be worked out by you and your team and your contemporaries on the other side. And you'll tell us lawyers and we will just write it down. And then there will be a financial model in the background, and it's crucially important that the words that we write down as the lawyers match the model, because the parties will really use the model to understand what payments they're going to receive. The other is a lockbox, and a lockbox takes a snapshot of the business at an earlier date. So it might be the last year end, it might be a quarter date, it might be the month before completion occurs. And then there is a mechanism which basically prevents the sellers from withdrawing money from the business outside of ordinary course, things like expenses and salary and pension contributions, to make sure that they don't leave the business without sufficient cash to continue to operate. And often there will be a mechanism that allows some kind of nominal or estimated profit for the period between the lockbox date and completion to be paid over to the sellers as well.
That's fantastic. And in terms of how the consideration will be satisfied, are there any other things sellers should be mindful of there in terms of what would feature in a heads of terms?
Sure. This again is an issue which needs to be discussed, particularly when it comes to deferred consideration. Consideration comes in a number of forms. From a seller perspective, cash is best. Sometimes there may be an element of rollover into shares in the buyer, which we've discussed before and is very common in private equity transactions, or where you have a listed company buyer. And if there is deferred consideration, there are a couple of ways that can be dealt with, which are often tax driven. Sometimes what you can have is just a simple mechanism in the agreement which says, this payment is due on this date. And sometimes you will have something like loan notes if you want to generate a particular tax treatment, and so you will be issued a separate acknowledgement of a debt, which can be used to obtain a desirable tax result. We have discussed some of these questions in more detail before, and the description of the video includes links to those discussions.
Brilliant. And beyond consideration, which already sounds like there's a whole host of elements that form part of the heads of terms, what else is important for sellers? Perhaps things like some of their personal terms and their journey in the buyer, whether that's trade or private equity.
Personal terms are really important. You won't necessarily get massively down into the nitty-gritty of things like salaries in a set of heads of terms, but it is important that the buyer and the seller have alignment on the seller's ongoing business involvement going forwards. Some sellers may see this as a retirement sale. They may want to go and sit on the beach for the rest of their life enjoying cocktails and their well-earned rewards. Other sellers may be at an earlier stage in their career. They may need to keep working and want to keep working in the business. They may want to join the buyer because it provides more opportunities for them. Similarly, from a buyer perspective, sometimes they may just want to get rid of the existing management team, particularly if they're not very involved in the day-to-day business, and there's actually a good management team underneath who are running it, and so they don't have to worry about paying those costs, which helps them generate value on the transaction. Other times they may think that the sellers are absolutely crucial because they are the people running the business and really want them to stay around for a few years. So having expectations kind of aligned on that is really important.
Thank you. And in terms of any conditions to completion, you know, what typical things would you see or expect to see within there?
Conditions to completion come up mostly when there are key issues which need to be addressed to allow the transaction to be commercially viable for the buyer, or even legal. So it might be that there are regulatory consents required. You know, regulators may need to grant change of control consent. There may be overseas investment in UK companies issues, which mean there needs to be government reporting if it's the business is in one of the restricted areas. And really the parties have no choice in those circumstances but to have a gap between exchange and completion to allow that to be dealt with. There may also be more commercial issues which need to be addressed. So it might be that there are key customers who have change of control consents in their contract, and you need to make sure that they are going to grant those consents before you complete. But the seller obviously doesn't want to take the risk of talking to them about a desire to exit until they know that that is going to happen, subject to satisfaction of the conditions. Any issues like that, if you can flush them out at the start, really helpful, because it allows the process to begin, and people can start thinking about, okay, how are we going to deal with this? If there's a key customer who we're going to need to talk to, what's the best model to deal with it? Is it that the sellers go and talk to them separately? Is it that the sellers take the buyer? Should it be a presentation? You know, all of those kind of practical political things to make sure that everybody gets to where they need to be.
Certainly, and I think from a timeline perspective and just mapping out when that's going, all of those elements are going to happen and who will be responsible can make a huge difference when it comes to actually executing all of those and impacting deal timeline. Certainly we've seen, and I know you and I have spoken about this before, on the National Securities and Investment Act front, and how the timing can vary on that, or FCA approvals. And I think it's really important to factor those in, as well as the commercial issues you mentioned. I wanted to ask now, John, in terms of any of sort of the legal protections for sellers that might feature in the heads of terms. What else are you tending to see in a heads of terms?
So sellers of a company are required to give warranties, which basically give the buyer comfort that they have been told enough to allow them to understand the business and that nothing unpleasant is going to come out of the woodwork after the event. Sellers are very happy to do that. Typically, they understand their businesses, but they also want to be protected, because once they've got their money, they want to be able to take it to the beach and buy their cocktails. They don't necessarily want to have to give any of it back. Certainly not if it's a minor issue. It should be relatively significant. The protections that sellers get are generally quite lengthy, and a lot of them won't be mentioned in the heads of terms, but some are quite frequently. These would be things like the periods for which warranty claims may be bought. Now, for tax warranties, that's a pretty market standard 7 years. But for commercial warranties and what are called fundamental warranties, which you sometimes see these days, which go to things like ownership of the shares, there will be potentially different periods which need to be negotiated. Similarly, caps on seller liability. Back when I started, the cap on the seller liability used to just be the price. And that was that. These days, it may be less than the price. It might be a negotiated percentage. That's more common in larger deals, because it's less likely that there will be a claim for £100 million than a claim for £1 million. It's just the nature of how wrong something would have to go to change the price by £100 million. So it might be that there's room to negotiate a lower cap. That would have to happen at heads of terms stage typically, and again, distinctions might be drawn between fundamental warranties and other kinds of cover. You might also sometimes see minimum claim sizes included in the heads of terms, so little things that are considered to just be not worth arguing over, and a basket, which is a level of claims as a whole, under which the sellers don't have to worry about any issues. You'll also quite often see addressed if there's going to be warranty and indemnity insurance, which can be a really effective tool for giving sellers comfort that they aren't going to have to give any money back, because if there's a problem, the insurer will pay. Because that needs to be dealt with in the transaction documents and policies put in place, it's important to discuss that at heads stage as well, so you can agree if that's going to be part of the mechanism and who's going to pay for it. It's usually the seller one way or the other.
Yeah, and I think we've seen differing approaches to W&I insurance and the discussions around it that happen at heads of terms, and indeed shortly after that as well, because it can impact timing. Often means there's a requirement for external formal due diligence reports, as opposed to some trade buyers who may typically want to conduct diligence themselves, but actually the insurance would need a kind of external party report to rely upon, which they need sort of time to do. So all these things are really important. And speaking of timetable and diligence, kind of how do those feature in a heads of terms? What should sellers expect?
So timetables you see sometimes, but not all of the time. They can be useful to set expectations as to how long it will take for the deal to be done. And it's relatively common to put in a target date. You do also sometimes see more detailed timetables, particularly if you're trying to do it on a very quick transaction basis, so that there's a marker for all parties about, okay, here's our deadline and we have our phasing, and everybody needs to work to hit what they've got to do so that we get there in time. That is, as I say, slightly less common. Gantt charts with timetables always fill me with fear as a lawyer, because you never quite know what's going to come out of the woodwork when you start. But it does. It's a really useful tool potentially in holding people accountable and making sure tight time scales are met.
That's great. And how about diligence streams? I think I've tended to see it quite a useful tool to set out at the outset what potential types of diligence the purchaser, whether trade or private equity, might be intending to pursue.
Yeah, you will see those sometimes. I feel that you can put too much detail in on that. I think most transaction teams will have a view, unless there is something particularly unusual about the business that might require somebody beyond the normal kind of lawyer, accountant, maybe insurance, broker due diligence teams to be involved. So, for example, if you need regulatory compliance consultants to come in to make sure that regulatory rules are being complied with, you might well mention that, just to make sure that there was an expectation set and all the parties are going to cooperate with that process.
Definitely. And I know we talked a little bit earlier about the regulatory approvals that might be required. I think the other one is in terms of any board or investment committee level approvals that might be needed in order for the transaction to go ahead, which are great to have written down and everyone's expectations managed at the outset.
Yeah, particularly with very large institutional buyers or sellers, or ones which are in a regulated sector where they might have to go kind of quite high up above the deal team in order to get final approval, which can be quite a time-consuming process. Exactly.
And finally, I just wanted to ask the question that my sell-side clients often ask me is sort of, by signing this letter, what exactly am I signing myself up to in terms of any binding elements? So what are the binding elements of the heads of terms?
So as I said back at the start, actually very little of the heads of terms are binding. They are really about setting deal expectations, and as people used to say, nothing's agreed until everything's agreed. So you'll find that mostly it is just to allow us to draft documents. There are a couple of exceptions to that, however, which is confidentiality and exclusivity. So there will sometimes be confidentiality obligations in the heads of terms, particularly if there has been no disclosure of confidential information as part of the kind of pre-negotiation process to allow the buyers to put a value on the business. So you could find those as binding terms. The second is exclusivity. Buyers obviously will want some comfort, particularly if there's a competitive process or an auction process, something like that, that the sellers aren't just going to cut them off at the knees at the last minute when they spent a lot of money and time assessing a business and negotiating and go with somebody else. So they may ask for comfort that there'll be a period of time in which the sellers won't negotiate with somebody else, and the sellers will want an exit mechanism built in, so they're not committed for a couple of months should the buyer decide for whatever reason they don't want to proceed with the transaction. And those would also be legally binding, so the parties can enforce them.
Thanks very much for that, John. And I think on the latter point, particularly what we've seen work quite well in terms of giving sellers that comfort is having a regular cadence of reconfirmation from the buyer of price, say on a weekly basis. It helps from the sell side give that sort of, you know, exclusivity for period up to potentially 12 weeks, knowing that they aren't going to have an unexpected price chip come in at any point in time. So I think things like that can really help to set out at the start.
Excellent.
So thanks very much, John, for your wise words and on heads of terms. I think it's safe to say it only really scratched the surface of it. It's a really complex area, but a really useful tool as well when you get the balance right between level of detail for both buyers and sellers. So if you are thinking of selling your company, looking at making an acquisition, please don't hesitate to reach out to either John or myself from the legal or the M&A perspective, and would be happy to talk more.
Great. Thanks very much for having me, Meera. It's been a brilliant conversation.
Thanks, John.